Court rise. I feel butthurt in the matter of Sky Ltd and others and Sky UK Ltd and another.
Mr. Hobbs.
My Lord, I had an opportunity to look at the transcript from yesterday, and I'm comfortable for my part that I didn't misrepresent my learned friend's case in my submissions to your Lordship towards the end of yesterday afternoon. There is something I do want to return to in relation to the very stimulating exchanges between myself and the bench in the last 10-15 minutes or so. Rather like Icarus, I flew a little close to the sun, but unlike Icarus, I like to think on the transcript that I flew away from the sun before the wax on my wings melted. I have in mind what your Lordship, particularly Lord Justice Newey, may have in mind. It was when my Lord put to me twice, for your note, it's page 322 and 323 of the transcript yesterday, that my Lord put, "You're not challenging," and then "It's not open to you to challenge." And then I was thinking on my feet, and there were exchanges, coming backwards and forwards. I want to be clear as to where I'm ending up on this. There were questions that were put to me by my Lord Christopher Floyd, and there was a question put to me by Lord Justice Nugee. I specifically said yes to the question that was put to me by Lord Justice Nugee. I noticed that although I was agreeing with it, I didn't say in a single word yes to what my Lord Justice Floyd put to me, but I mean yes. And in each case, I added some further observations of my own. Now, the point that my Lord Sir Christopher Floyd put to me was on the word "moreover." My Lord may perhaps remember it. That was on, by the time we got to 329 of the transcript, my Lord puts to me, "You say there's a false premise built on his finding in the sentence that begins with 'moreover.'" And I didn't say yes, I meant yes. And then I amplified my answer. I went too quickly to my own elaboration of the point. Now, what I want to impress upon you, if I may, so I'm going almost full circle to when I opened this case, I am submitting to your Lordship, and the background to this is, of course, I'm as aware as the next barrister of the case law relating to what's sometimes called standard of appellate review, multifactorial analysis. It's bread and butter in the Court of Appeal now. In a way it wasn't maybe even 10 years ago. My case to your Lordships is that the paragraphs that we were concentrating on in the judge's judgment, so it's 250 to 252, and the carry forward of them into paragraph 21 of the third judgment, my submission to your Lordship is that they are vitiated by errors of law. And the factual analysis has become tangled up with the errors of law. The errors of law are the two blind spots that I identified when I got up to speak to your Lordships at the beginning of day one. You're very familiar with the second of those blind spots, as I call it, which is the one about it being an identification of a kind or thing, not a catalogue. That's the language in the specification. The first of those two blind spots is the one that I've pressed your Lordships on, that it's registration, title by registration, not registration of title. Would you mind if I cast all my shyness and natural modesty on one side and cite a decision which I have issued in another capacity, which is on your bench? This expresses, in the form of a reported decision, the point that I was making as my first blind spot to your Lordships. I prefer to cite it myself. My opponents always derive exquisite pleasure from citing my decisions against me. And I like to perform a little bit of jiu-jitsu and speak first if I can. So this is a case where it was rather like a case which my Lord Justice Newey will remember, where they gave judgment in the Court of Appeal last week. It's one of the pop group cases. It's one of those where there's a leaving member and there are others left behind, and who's got the name. It's one of those cases, and there's a steady stream of them. This one did not raise the same issues as the one that my Lord's dealt with in the Court of Appeal last week. This was the swinging blue jeans. and there'd been the usual thing. There were leaving members, there were remaining members, there were people wanting to use the name, and there was a conflict, and it came to a head in an application for registration. The novelty of the case legally was that the attacker, the person who wanted to challenge the registration, wanted to use a rule, section 64 of the 1994 Act, which is a rule which allows, a provision which allows rectification of the register. So they wanted to try and bypass what would be section 3.6, bad faith. They wanted to try and bypass what would have been section 5.4a, the earlier right, unregistered right, and they wanted to go straight to use the rectification provisions of section 64 of the Act. And it was necessary for the decision taker to explain why you couldn't take that abbreviated route. And it's the explanation given in that connection I would respectfully invite my Lord's attention to. It fleshes out what I have been submitting was the first blind spot of the two. If I may therefore ask you to turn in the decision, I can pick it up probably at about paragraph 8 towards the second half. Actually, I'll pick it up at 8 in full. So, the nature of the dispute between the parties is readily apparent. The filing of the application for registration as a trademark for services of the kind specified was plainly designed to enable Alan Lovell to retain for himself, so far as he could, the benefit of the goodwill and reputation which had been built up and acquired over 46 years. Then you go down approximately 4 lines from the end of that paragraph. Alan Lovell did not accept that he'd done anything wrong by applying for registration as and when he did. He didn't claim to have acquired any right, title or interest in or to the relevant goodwill and reputation by transmission. His position was that there was no lawful impediment to the filing of the application for registration in his name on the 26th of February 2010. The question whether there was or wasn't a lawful impediment to the filing of the application for registration had to be asked and answered in the context of the EU system for the protection of trademarks by registration at the national and community level. This operates on the premise that a registered trademark is a property right obtained by registration of the mark under this Act, that's section 2.1 of our 1994 Act, and then the parallel provisions of the EU TMR, as they now are, they've been carried forward. Once again, they echo each other. The observation in 9, these provisions, together with the rules for obtaining and retaining protection under the Act and the regulation, establish a system in which title to a protected trademark arises solely by virtue of an entry in the register, identifying the natural or legal persons to whom the original certificate of registration is issued on completion of a procedure initiated by a simple request for registration filed in the required manner under those provisions. For more than 100 years prior to the commencement of the 1994 Act, it was appropriate to proceed upon the basis that the legislation in force in the United Kingdom factored the dual concepts of title by registration and registration of title into the system for claiming protection at the application stage. So I started with section 62 of the legislation from 1883. The controller may on application by or on behalf of any person, and it's the words claiming to be the proprietor that the courts would focus attention on. And you would raise an objection on the basis, well, he's made a claim to be the proprietor, but he isn't the proprietor. And it would therefore create an additional threshold requirement.
The 1938 Act had a concept of a trademark, a common law trademark, as it were, that you had, irrespective of registration.
It abolished it, my lord.
Yeah.
So you get, this was dealt with in a case called 1 in a Million in the Court of Appeal in 1999, FSR page 1, in which they said that there used to be a thing called a common law mark, and it subsisted until you got the 1938 Act when it was cancelled.
Yeah.
Right. But for present purposes, I've got the 1883 Act, which I start with. Then you have the corresponding provision in the 1905 Act at the top of the next page. It echoes the wording claiming to be the proprietor, and then at 17.1 of the 1938 Act, which continued in force subject to transitional provisions until the 31st of October 1994. Right, so the narrative goes on. However, There is no legal or administrative requirement under the 1994 Act for a person requesting registration to make an a priori claim to proprietorship of the trademark he's putting forward for protection. The present system factors nothing more than the concept of acquiring title by registration into the application stage and leaves it to those who would wish to contend that title has not been validly acquired to object on grounds available for that purpose under the Act. Although trademark rights acquired through use remain protected, they are taken into account only in regard to the relationship between them and trademarks acquired by registration as envisaged by the legislative provisions. So rights acquired by use and disputes about rights acquired by use come in through the relative rights machinery, often if it's an unregistered right, or always if it's an unregistered right, via section 5.4. Now, I don't need to go further. So, as I say, putting modesty on one side, what I'm saying to your lordships is something I've said before. It is in a reported decision, and your lordships have it, and your lordships will make of it what you will in due course. But the point that I do want to make is, I did fly close to the sun, but I am saying that the reasoning in those paragraphs, the key paragraphs for your lordships' purposes, are vitiated by error. And if I may add something in the nature of a little bit of a cri de coeur, the case law, which is relentless from the Court of Appeal and indeed from the Supreme Court, to the effect that multifactorial decisions and so on and so forth have they're treated in a certain way in the Court of Appeal. There's a view that's gaining ground that perhaps shouldn't. People are getting the impression that the Court of Appeal won't scrutinise the decision, won't grapple with it, won't engage with it. It's a hands-off approach. I do, without any impertinence, say we do still scrutinise decisions. We do examine them. It's just that if, upon and when we have done so, we come to the conclusion that it isn't wrong, which is the statutory test, it isn't wrong, then it be left alone. I wasn't proposing to go to the Hasbro case. I don't feel the need to do it, and in particular I don't feel the need to do it because of the observation that is in the transcript from my Lord Justice Floyd, which is the explanation for that decision comes into the proposition that they quite deliberately took steps to bypass the non-use provisions, the 5-year non-use provisions. They took steps to bypass it, and their conduct and behaviour and the reasons that they gave were found to be sufficient to justify a finding of bad faith. The decision itself is not uncontroversial, by the way. The chances are there will be an attempt to take it further to the Court of Justice, but then they have to get the equivalent of permission to take it there. My understanding is that they may take that path. In terms of English law, we have two decisions, one of the Privy Council and one of Mr. Justice Jacob at first instance, in which we've actually held, albeit under the 1938 Act, that there's nothing wrong with doing that. The case in the Privy Council was one involving Cusson's Imperial Leather trademark, and they followed in the Privy Council the decision of Mr. Justice Jacob in Origins Natural Resources. But I'm being parochial when I say that. That's our national approach to this. It's not the present state of it on refilings in the EU. We shall see what happens. But as I say, I'm not seeing that case as one which treads on our toes, or my toes anyway, here.
When you say there's nothing wrong with that, you mean with evergreening?
There's more to be said than I see said in that judgment, and more than I see said on behalf of the people who argued the case. But that's counsel saying I might have argued it or decided it differently, my lord. But I'm content, if your lordships are content, to just let it rest on the point that my Lord Justice Sir Christopher Floyd put.
And so far as what is meant by bad faith is concerned, do you what do you say about the frequently cited passage from Mr. Justice Lindsay's decision in Gromax? Is that a fair way of expressing what bad faith is? That is to say, not just dishonesty, but a little bit more.
Okay. So I may break my rule then and just for a second look at the relevant paragraph in Hasbro. You've probably got it in mind. They did a similar thing.
Well, I wasn't going back necessarily to, I understand what you say about Hasbro,
Yes.
but is Hasbro really out of step with what Mr. Justice Lindsay said in Gromax?
I'm slightly like this about this because you may remember, you've seen it in the patent cases, it's the Caliph of Baghdad and the Great Library at Alexandria. If it says the same thing as in the Quran, it's superfluous and should be burnt to the ground. Do you see, I prefer not to favour one over the other.
Okay.
But we have always worked, and I can see plenty of reflections of it in the EU case law on Mr. Justice Lindsay's approach. And we've always worked on the basis of it, but that was until we had the decision that we have in this case and its immediate precursor, which was Cotton. So now it would be right to switch to the language of the case we've got, not least because it is the law in the case that I'm arguing in front of your lordship. The passage in Hasbro, could somebody tell me which tab it is? Probably going to be one of the recent ones, so it's probably in volume 2.
42.
Is it the end of 2? Oh yes, it's 42. In volume 2 of the authorities, it's tab 42. Okay, so you've got it. The way I would answer is I prefer, given the history of where we are and the legislation that is given to us, the nuance, so dishonest or not, or I forget Mr. Justice Lindsay's formula, but if you look in paragraphs 40 to 42 on stamped page 542, their double barrel on not pure and simple dishonest is what you find in 41.
Or rather sinister motive.
Yeah. Always about motive. And you may remember in my opening I submitted to your lordships, the whole thing is about motive. It's a motive test. It has intention built into it. It has to be a nefarious intention. It's the very fact that they want to use those expressions, dishonest intention or other sinister motive, that causes the whole problem later down the line about how much massaging is there on the question of dishonesty, when dishonesty is itself, we all know, very contextual and very, what should I say, malleable. Dishonesty is a very malleable concept. But anyway, I'm going to answer in that way. I'd prefer you, with respect, not to locate in what Mr. Justice Lindsay said in Gromax, useful though it is, and always was. It informed many, many decisions here and in the EU system. We've now reached a point where we're focusing on dishonest intention and how much of an orbit is there around that.
Yeah, well, I suspect there's not much difference. There it is.
I don't know what a sinister intention is.
All right, thank you very much.
It's a little bit too philosophical for me, I'm afraid. Sinister. Judged by what criteria and by whom? You can see immediately where it goes. All right, so having said to you I won't go to Hasbro, I just did, but I'm not going to go any further into Hasbro than that. I want to just say a couple of things about the 10.3 case. Let us be clear about what 10.3 is and does. Hold for a moment the proposition of a case where there is confusion, a likelihood of confusion. There are two consequences that confusion can bring and almost inexorably does in its wake. There's the positive and the negative consequence. There's the positive consequence that it can bring an unfair advantage to the person who's causing confusion. And then there's the negative consequence, which is that it can inflict undue detriment on the proprietor of the mark against whom the confusion is occurring. Now, at the heart of it is the proposition that those two consequences, which I've described as the positive and the negative, The law now, when for a long, long time, especially in our country, it didn't, the law now recognises that those consequences are bad. And so what Section 10.3 does is to remediate against those consequences with or without the likelihood of confusion. They're as bad if they're occurring without confusion as they are when there is confusion. So in that sense, that gives you a perspective. That's why it is correct to say, at least in my submission, it's correct to say that there's no requirement for the presence or the absence of a likelihood of confusion. But if you have a likelihood of confusion, you must factor it in. But when you've factored it in, you still haven't exhausted the basis for liability under 10.3. You must continue the examination to the next stage, which is there either of those positive or negative consequences being inflicted, even though but there isn't confusion to the full extent. And there was a discussion, there were some exchanges yesterday about, I'm going to paraphrase, the wrong type of reputation. My learned friend says, oh, but you haven't got a reputation for the things I do. Well, I question that, but never mind. It's not a requirement. The whole point about Section 10.3, the way it's written and the EU legislation which it implements, the whole point about it is that you have it if you have it's available when you have a mark with a reputation, which, by the way, is not an onerous thing. But you have it when you have a mark with reputation, and then you go to the next inquiry. There's no requirement for the defendant's goods or services to be identical, but it matters if they are. There's no requirement for them to be similar, but it matters if they are. And above all, there's no requirement for them to be similar, which means they can be dissimilar, and you can still succeed in an action for extended protection. Therefore, as I think my Lord Sir Christopher Floyd was putting to my learned friend at one point, it's not correct to do more than to ask, is there a mark with a reputation? You take account of the strength of the reputation. And you go then to the question of, is there sufficient nearness to give rise to either the positive or the negative effect? And is it happening without due cause? It is as simple as that. And my learned friend is quite wrong, if I understood him correctly, he's quite wrong to be submitting that somehow it's the wrong type of reputation, or I've got to have a reputation in his field. No, that's not right.
Can I put to you an example that was put to him? The Rolls-Royce
Yes,
cafe.
yes,
I understand your submission to be that even though Rolls-Royce's reputation is in luxury cars
yes,
and not in cafes,
yes.
they could complain under 10.3 of the Rolls-Royce cafe if they could say
Yeah.
and establish that that was trading on their coattails.
Without doubt, without doubt. And may I say that in the last days of the 1938 Act, the judges struggled as hard as they could to get claims of that kind to run within the straitjacket of the legislation we had then. We didn't have the liberal measures we have now. So there was a case which was quite notorious, Rolls-Royce versus Dodd. Forgive me, it's in the law report. It was all over the newspapers. Mr. Dodd took a Rolls-Royce and put a 27-litre Merlin engine inside it and got sued for using the trademark Rolls-Royce and the Silver Lady in relation to this car, this mongrel car with a 27-litre Merlin engine in it. And just for good measure, as these things happen, of course, he parked it outside the law courts at the front there during the day of the hearing. It was everywhere. But if I recollect correctly, the claim succeeded, and I believe it was in the Court of Appeal at that stage, and I think it may have been Lord Justice Buckley. So yes, we struggled then, but since then, I'll give you just a couple of examples. Clarine and Clarine. So Clarine, or whichever way round it was, and I don't remember, one of them is a high quality gin, and the other wasn't. The other was a disinfectant. Okay, so not much likelihood of confusion.
Did you say gin or Jim?
Gin and gin. Mother's ruin, my lord. One was a high quality gin and the interloper was the disinfectant. And the interloper got stopped. No good saying my goods aren't similar. It's no good saying that I'm not causing confusion, because no sane person would be confused. What happens is the mark is treated, and the reputation alloyed to it is treated as an economic asset, liable to be whittled away or dispersed by conduct of that kind. And can you imagine, there is nothing more off-putting than to have in the mind of a consumer that is about to take a drink of a fine gin, the connotations at the back of their mind or the front of their mind about a disinfectant. You can just imagine. Another one, which is a decision, it's actually a decision of mine, Visa for financial services, stopped Visa for condoms. And of course, it's in the law report, it's in the judgment. The question arises, how was it that they wanted to use Visa for condoms? And counsel, with a completely straight face, said, we chose it because we were making a skillful allusion upon the concept of a permit to enter. Now, you can see, my lords, that sort of thing which gets said repeatedly when the goods are disparate, nobody in their right mind would think we're too far away from you, and all of that sort of stuff. This law exists for the very purpose. So I do answer straightforwardly, without hesitation, yes. Whether it measures up in the factuality of it's another thing, but yes, in principle. Now that leads then to a point that my Lord Justice Sir Christopher Floyd pressed upon my learned friend more than once and didn't get an answer to, which is the point about, well, suppose you have a brand and you are conscious that for brand protection reasons, not least having at the back of your mind the modern scope of protection you can claim for a trademark, that you want to protect your brand, and you genuinely believe when you file for your list of goods and services that they represent areas in which, if there was use adverse to you, it may tread on your economic toes. It may whittle away at or disperse your goodwill. And the answer to that is already in the case law. If you were to have our skeleton, so it's our appeal skeleton, Core 1 tab 4. And in our skeleton, it's paragraph 59, we reference the relevant passage of the Lint Bunny case. That, I believe, answers the point.
To which a response may come, well, you don't need to apply that broadly because section 10.3 will avail you in due course when you come to stop people.
Which then takes me to the next point, which is vigilance for the protection of brands has been noted by judges for decade after decade after decade. You have to be vigilant in the protection of your brands, otherwise you will find you get crowded in on, and with the passage of time your rights get whittled away. Most brand proprietors with a valuable brand act for the protection of it, and their general approach is to let the judges decide the limits of their rights rather than self-deny on a case that a judge might otherwise have upheld if it had gone to the full result with evidence, disclosure and all those things. It's actually not a very wise idea for a proprietor of a famous brand to determine the limits of his own rights voluntarily. It is rational and fair to have it tested, if the defendant wishes to have it tested in a court of law. Now, you win some and you lose some, but the one thing you don't do is voluntarily surrender your brand rights as you go along, and you do try to create elbow room around your brand. It's one of those things in this world. So the Rolls-Royce case was an example, but there are many others. People will crowd you in and your rights will be slimmed down. Now, you were told about 800 or so proceedings worldwide, let that be so. You were not told that they were all abusive, nor could the judge possibly have come to any conclusion as to whether they were or were not well-founded. whether there was or wasn't any legitimate justification, it certainly cannot be presumed, well, it just can't be presumed, adversely to my clients or at all, that there was negative behaviour, or that there was that if he can point to that one as being a stretch on the claim, therefore all of the others must have been bad stretches on a claim. You simply cannot do that. It is right for brand proprietors to be vigilant, and actually the fact that there are 800 of them and they didn't sue for all that they were aware of tells you that they've got a problem. It actually tells you that from where they're sitting in the room where the chap is metaphorically writing the specification of goods and services, they know they've got a problem and they want to create a zone which they can reserve and protect for themselves. But you will remember, always subject to law. Always subject to law.
Isn't one of the causes of the problem that they choose a very short, very ordinary English word, which other people also use? Whereas if you choose the word Rolls-Royce, nobody uses Rolls-Royce for any other purpose legitimate at all.
Well, my lord, may we just unpack that just a little? I'll echo what Lord Justice Templeman said in a case in the Court of Appeal once. No one would have the temerity now to say that legal and general was just a combination of two ordinary English words for financial services. So nothing is static in this world. That which looks ordinary becomes a tool for communication and commerce. It becomes the focal point for huge economic endeavour and investment of time, effort and money. It spreads and expands, and it acquires a life of its own. It's no more any longer just the word sky with a sort of celestial reference. Once upon a time, if I'm right in my memory, the Rolls and the Royce, there was a Mr. Rolls and there was a Mr. Royce. So it starts off in life, and to anybody when they first encounter it, oh, it's a firm and it's Mr. Rolls and Mr. Royce, or Royce and Sons, or whatever. But when you reach the point where you've acquired a massive goodwill and reputation, a high level of distinctiveness, and remember, the judge took the view, and he is an experienced, of course he's an experienced trademark lawyer and judge, that we had what he called a moderate, did he say moderate? He said at least moderate to high level of inherent distinctiveness. And of course, every element of inherent distinctiveness becomes augmented through use in the way I've just put to my lord. So it is, you'll forgive me for saying so, it isn't right to, one of the things that used to be said about the Chancery judges is, of years gone by, I'm not talking about any of the modern generations, always present company accepted, they used to construe trademarks. But no, you don't. And here's why. A trademark is a trigger. It triggers perceptions and recollections. The perceptions and recollections that are triggered by it are born out of the way in which, by nature and through nurture, it's come to acquire a status, and it has an asset value of its own, which is unlinked and divorced from whatever linguistic connotation it may once, in some stage in its history, have come to mean or bear. So the answer is, with respect, we're beyond all that in this case. And so they were rightly fearful, as any brand proprietor is, of protecting their investment. Now, on that subject, so I'm hopefully demonstrating to your lordship that my learned friend can't get anything out of the fact that there were 800 or so proceedings worldwide. Let that be so. For all I know, there could have been more. For all I know, that they were all or most of them well-founded. For all any of us knows, but they could easily be, and I say they might just as well be taken as symptomatic of the existence of the problem which goes into the exercise of designing or writing a specification of goods and services. Now, it was striking yesterday, when your lordships were pressing my learned friend, Mr. Malinich, about, well, all right then, so you say that you can file an application for registration for computer services, and it's not inherently bad. And you pressed him, well, when is it inherently bad? And at one point he was saying to your lordship, it depends upon the state of the mind in which it was filed. This is extraordinary. Because if you were to follow him down that primrose path, you will find that there won't be a case for trademark infringement in the Chancery Division in future in which the wide word, which is said to be acceptable as such when filed, isn't going to be the subject of some form of interrogation as to what the intentional mindset was of the person who adopted it. It's kind of like good and bad. It's like Schrodinger's specification for computer services. It's kind of good or bad depending on the frame of mind of the person who wrote the specification. This cannot be, especially when you bear in mind that it's an attack on validity at the filing stage. The mark might have changed hands. It's common. Trademarks are bought and sold as property. The mark might have changed hands. The people might have died if they get, or they might know, for all sorts of reasons, they may have dispersed. It may be impossible to ever know what the intention was. It cannot be the right approach.
I'll just drag you back to mundane questions.
Sorry, Mark.
Paragraph C, infringement, and paragraphs 319 and 320 of the judgment, which
That's our judgment.
main judgment.
Pause for 1 second, Mark.
Page 242.
Could you call those paragraph numbers again?
319 and 320, page 242.
Thank you, my lord.
Main judgment.
Thank you. Yes.
When the judge said if there's no risk of confusion, then he's not satisfied that you, Sky, had established any detriment to the distinctive character of the trademarks or any unfair advantage. What do we do with that?
Well, it's again the point that he's come into an analysis on a false basis. First of all, he's eradicated the notion of the likelihood of confusion, the existence of which he's positively found before he starts this exercise. That is a completely skewed way of looking at section 10.3 in the first place. If I'm right in my submission on the B clause, by the way, that he undersold me on the question of how much protection I have under the B clause, that magnifies the size of the error of not taking it into account when you get into the C clause. And anyway, it doesn't matter. You cannot do this bifurcated thing that he purports to do, which is to cross out of your mind the actuality of a likelihood of confusion and pretend to decide the case as if it didn't exist. It's unreal.
Well, that's why I've been rather confused throughout this case. Are you asking us to reverse the judge's conclusion on paragraph C infringement in the absence of confusion?
Forgive me, is my lord asking me whether I accept, in other words, meeting the judge on his own ground?
Yeah.
I would, but I can't meet him on his own ground because his own ground is completely wrong.
Right. So you say he should have taken into account the risk of confusion when considering paragraph C infringement, and if he had done so, then he would have found detriment to the distinctive character of the...
Because confusion has that sewn into it, and even when he'd finished the exercise by transposing from the B to the C clause, there was still a residual question.
Oh.
He treats the residual question as if it's somehow the only question, and he answers it without having answered the antecedent question, how much B clause?
I just wanted to make sure where we were in terms of the structure of the appeal, and that's very helpful.
Thank you.
Does that mean if there is a likelihood of confusion, which is what he found under B, when you come to C, it doesn't necessarily follow that there's either detriment or unfair advantage. It's an extra question.
I'm going to answer in this way. There is Court of Appeal authority. There's always an authority. Eshaw versus Direct Line is a decision of the Court of Appeal. Lady Justice Arden, Lord Justice Jacob, and he will forgive me, but I can't quite remember the name of the third member of the court. They agreed in the judgment, and Sir Robin and Lord Justice Jacob said, when there is a likelihood of confusion, then and therefore you've got the consequences for a C clause objection. You've got the consequences preempted by C. So yes.
It depends a bit on the nature of the likelihood of confusion, because
Yeah.
likelihood of confusion comes from the B paragraph.
Well, it does, but let's just hold this point because there's a crossover line. Imagine a diagram. Three concentric circles. That's double identity. Outside that is a penumbra. The penumbra, occupied by the B clause, is there. Now the size of that B clause, the size of that penumbra depends on the view you take of similarity for the purposes of the test for infringement under B. The greater the similarity is, or the broader you construe the concept of similarity, the further out that penumbra goes, leaving what you might call a thinner or smaller outer penumbra around it for the C clause to operate in. However, if you unduly restrict the scope of the B clause by taking an over-analytical view of what constitutes similarity of goods and services, then you just create a situation in which more work has to be done at the analysis stage on the outer penumbra for the C clause. Now there's a debate, and it's not been run to ground even yet. There's a debate. Does the B clause, by virtue of that similarity provision, does it require the equivalent of what we used to call in passing off a common field of activity of some kind or another? And that arises in this way. Is the word similar to be construed in some sort of structural way, or is there an element of perception to it? The answer in the case law probably is there's an element of perception to it. So I'll give you a good example. I'll give you an example. Would refrigerators and air conditioning equipment be regarded as similar goods? There are plenty of people, most of them sitting at in examiners' offices in trademark registries around the world, who would say, no, they're not similar. And there are others who'd say, well, hang on. The technology which is deployed makes it more than highly plausible that a person who was using a certain mark in relation to refrigerators could just easily use the mark for air conditioning equipment because the technology is what you might call kindred technology and they are kindred goods. Now, I don't want to get caught up in too much of this because although it is very important, because where you end up on the similarity thing determines how far you then have to go when you get to the C clause. That's the point I'm trying to make. It's elastic, it's movable, and the judge, by doing what he did, really rode roughshod over the exercise altogether. Have I said enough for your lordship's purpose?
I think so, yeah.
I think I may have said too much.
I'm sorry, can I just ask you?
No, I'm delighted.
Having a look at your diagram,
My diagram, yes.
it tends to suggest that everything that's within the B clause is also within the C clause. Is that the case?
Usually. Usually. It was predicted at the early stages of this legislation that why would anybody who had a mark with a reputation bother to sue on anything except the C clause? But nobody's been bold enough yet.
I mean, if it were the case that you have these circles and everything in the B clause is within the C clause, then what's wrong with what the judge did, which is to say, well, if there's a likelihood of confusion, you're in the B clause. So I'm only going to look and see if you fall within the C clause on the assumption there's no likelihood of confusion, i.e. you're in the outer strip.
I know. Because the reason it's in the C clause is because of the likelihood of confusion, the existence of which he discounted when he got to the C clause. You can't discount the existence of a likelihood of confusion when you do the C clause. That's where he went wrong.
But he said if there is a likelihood of confusion, it just overlaps. So I don't need to consider that separately. So it's only if I'm wrong on likelihood of confusion that I need to look at C at the outer edge.
It's the wrong way round, with respect.
Okay.
The wrong way round.
Well, I think I understand the way in which you put it.
go on for hours, but I won't. Unless you want me to. If your lordships beg me to, I will, but otherwise I won't. Give me a second. Right. I found myself sitting here yesterday wondering whether I was having a heated agreement with my learned friend on class numbers. Did I ever say, if I did, I didn't mean to, but I don't think I did. Did I ever say you strike it out and ignore it? I don't think I did. I'm just trying to say it doesn't have determinative effect on questions of similarity, hence liability, for any of the other purposes for which you need to look at it. I gave you the example, which, if it ever arises, and I'm pleased to see and hear that they're not suggesting it's this case, of the cow being led into the sheep's enclosure, and do you deem it then to be a sheep, or do you ignore its very existence, or what do you do? We can worry about that case if and when it arises. At the moment, they're not saying, unless I'm mistaken, I hope not, they're not saying that a cow's been led into a sheep's enclosure. They're just saying there's a sheep of a certain type in the sheep's enclosure, which is fine. The class number then goes away. It's got nothing to do with it. You're looking at a sheep. Sheep go there, class 42. And then you do the rest of the analysis. The rest of the analysis is a concrete, real-world analysis. It's not a cerebral, intellectual exercise based on the teachings of the people who write the Nice Agreement, who periodically revise it. It's nothing to do, it's not a cerebral exercise of that kind. You just move to the real world and the concrete situation. You look at what you're looking at. So, as I say, it may have been, I think we've ended up having a heated agreement. Section 60A, he professes not to understand it. What is there not to understand about Section 60A? It's very clear. And what's more, Section 60A is one of those legislative provisions which is declaratory of what the position always was on the case law. And certainly there's case law in the Court of Justice. That's why we cited and put it in the reading guide. I can't pronounce its name, but the Eastern European name. Do you remind me what it's called? Anyway, that case, to show that it has the point has a pedigree going backwards. It's always been well understood. You can't use the class number to trip up a claim. It might, in the Altechnic situation, trip up a request to get out of one class into another, but you can't use it to trip up a claim.
I think speaking for myself, what I'd appreciate help on is the actual construction issue which faces us, which is electronic mail services.
Yes.
And whether that is restricted to
Yes.
Gmail, if I put it that way, or whether it has a wider connotation and includes services related to email, such as
Yes.
migration service. And that's what I've got to decide.
You have.
Oh.
And then there's related to that the question of whether telecommunication services nonetheless gets it.
Yeah.
There is a person not far from me on my left who is waiting like a coiled spring to assist
I
your
imagine
lordship.
he's rearing to go. Yeah.
No, my lord, I feel like I'm blocking him again from speaking. He's waiting like a coiled spring to assist your lordship on that point. Okay then, you've got the argument, it got a light touch, deservedly. This question of the strikeout. So I called it the microcosm of the macrocosmic jackpot argument. They can't strike out the whole lot, so they just want to focus on the 8 and strike them all out one by one. I don't quite know what the logic of it is, but I suspect it's this. That when you look to see what it is that is in the crosshairs for the purposes of the attack, you're looking at something which is a component of a list. It's a single expression, computer software, telecommunication services. And you just look at it and you shoot it down, or you don't shoot it down. Well, no. If you could take the CJEU judgment, which is in the core bundle, behind tab 15. I'm going to pick up in this judgment as quickly as I can just point the paragraphs to you. The use of the word covered or covers. And the cutting down exercise is relative to what is covered, not to what is the label applied to what is covered. So in this judgment, if you turn to page 303, stamp page 303, in paragraph 15 there's a reference to a legislative provision in the regulation. And this is one of many legislative manifestations at this point, where, so it's Article 38, where under Article 7 a trademark is ineligible for registration in respect of some or all of the goods or services covered by the community trademark application, the application shall be refused as regards those goods or services. It's the word covered. As quickly as I can do it, if you go to stamp page 315, we're into the third and fourth questions. Dwell for a moment on paragraph 72. The trademark application made without any intention to use the trademark in relation to the goods and services covered by the registration constitutes bad faith. And you see the expression covered and covers in the penultimate line again of that paragraph. It appears again 4 lines into paragraph 73. You get to paragraph 79. Is the actual cutback provision, the proportionate cutback provision. Concerns only certain goods or services covered by the registration. The invalidity of that trademark covers those goods or services only. In the operation of these and all the kindred provisions under the EU legislation, there's always been a consistent position.
Read the next.
No, I'm not going to. You can read it when you get up. You've got to reply. You've got a position in which there is always a trimming down of what is there. You do not throw the baby out with the bathwater. And that is, if there's an exception to it, then I don't know about it. Or there would be if your lordships were to accept what my learned friend is saying. I've got another way of looking at this too. When you come to the fourth judgment, I don't think we've looked at that together, but now is probably a good time to do it. If we come to the fourth judgment behind tab 17, the judge deals with, the major part of this judgment on the question of relief is about should there or shouldn't there be an injunction. It was being strenuously opposed. In the end, the judge decided that there should be. He goes through a lot of law, some of it in the form of legislative materials, some of it in the form of case law, a lot of discussion of principles and so on and so forth. And then if you come to his heading on stamped page 345, which is the assessment, he had been urged by my learned friend to say no injunction, because to grant the injunction would give effect to and enforce this wording, and this wording is obnoxious, and is obnoxious because it's representative of obnoxious behaviour, and you would be rewarding obnoxious behaviour on the part of Sky. And he addresses this, and you'll see the heading sanction and deterrence, where all the arguments come. And proportionality is factored into paragraph 42. So you've got sanction and deterrence and proportionality, but they ran an argument on sanction and deterrence, and they ran it strenuously. You'll see the logic which is spelled out in 38 of the submissions. Counsel argued Sky were no worse off than if they'd only applied to register the trademarks in respect of those goods and services which were unaffected by its bad faith. Paragraph 39 I concentrate on with you, if I may. I don't accept that submission for 3 reasons. First, it's clear from the CJEU's judgment that the sanction for applying to register a trademark in good faith with respect to some goods and services, but in bad faith with regard to other goods and services, is that specified by what is now 59.3, namely, partial cancellation of the resulting registration in respect of the latter, but not the former. As interpreted by the CJEU, the legislation does not provide for total cancellation in the event of bad faith. It is implicit in that interpretation that bad faith, which affects only part of the specification, does not taint or infect the remainder of the specification which has been applied for in good faith. Thus, the two parts of the specification are to be treated as distinct property rights that stand or fall separately. It is true that in that sense the trademark proprietor is no worse off than if it had restricted the application to the remainder of the spec in the first place. It doesn't follow that there is no sanction for or disincentive to such conduct. What it means is that the principal sanction is precisely correlated with the wrongful conduct. Furthermore, a procedural system such as that of England and Wales, where costs follow the event, the trademark proprietor is likely to suffer cost consequences as a result of partial cancellation. Accordingly, I don't consider that partial invalidity of the trademark can amount to a special reason justifying refusal of an injunction to restrain future infringement of the valid part of the registration. Now, there were other reasons, but I won't dwell on them. We get to the end of the fourth judgment. The judge has delivered it in draft as a reserved judgment, and I think we had it for about a day. And then, in characteristic fashion, we received a midnight missive from my learned friend with an application for permission to appeal, which is dealt with in the postscript. In the postscript, the judge says, paragraph 76 on stamp page 254, after the foregoing judgment had been circulated, Skykick filed further written submissions seeking permission to appeal on 3 further grounds. The first 2 concern my conclusions in the third judgment as to the extent to which the specifications of the trademark should be cut down, having regard to my bad faith, and that's the point, that's what my friends just argued. Skykick contend that the relevant parts of the selected goods and services should either be excised in their entirety or more severely pruned. No explanation has been given as to why permission to appeal on these points is only being sought now, which I would add in circumstances where it was scarcely argued. Moreover, success on these points would not affect the finding of infringement in relation to cloud migration, so he gives permission. You've heard the argument, but then look at what he says on the last 4 lines. Skykick also seek permission to appeal my decision to grant an injunction, which is not a matter they could have raised before. That decision was an exercise of discretion, however, and no error of principle has been identified by Skykick, and he refuses permission to appeal on that ground. No error of principle. So when I showed you that paragraph where he says, I'm not going to accept this argument that they shouldn't have an injunction to enforce for the residue of what's left after the cutting down, he says on the refusal of the injunction point, it raises no error of principle, I've done nothing wrong, I've applied the law correctly, and then it's like whack-a-mole, it comes up in disguise on the 2 grounds that he's given permission for in the first half of paragraph 76. It's the same argument at one remove. The judge was right in what he understood to be the effect of the ruling on the 4th question. The judge was right to take the position he did, refusing to accept the argument that was put to the effect that the wording in question should be treated as if it didn't exist. He said it was raising no error of principle, and what he's actually done is to allow a point to be argued on appeal, which is as near as could be the same point that he's just said has no error of principle in it. There is no error of principle. His reasoning in that respect was entirely orthodox, and there's no justification for going any further, as my learned friend would wish to be the case. And I think I'm going to sit down now.
Lord, as I did, it would help with my reply submissions. Is my learned friend, could I ask the court, please, to ask my learned friend to clarify
Mr. Malrich, could you take your mask off?
Oh, sorry.
To
To clarify whether he is supporting the judge's extent of validity cutting down by the last submission that he has made, or whether he is still requesting that the judge's invalidation exercise should be completely reversed. Because I'm just not clear as to what Fred wants.
Well, that is a pretty remarkable question. Pretty remarkable. In circumstances where I could not have made it clearer that what the purpose of my appeal was, which was to reinstate, if I can put it that way, the whole of that left-hand column. I could not have made that clearer. And what I am doing, because now is the point in the timetable for me to do it, is responding, demonstrating why the argument put against me shouldn't be given any intellectual house room in your lordship's court.
Can I just break that down a moment? You say no cutting down because no bad faith.
Correct.
I don't know whether Mr. Malinich is concerned beyond that. Supposing there is bad faith, is the cutting down appropriate?
The method that the judge used, he says the judge should have gone further. The judge should have just knocked them all out completely. That, if your lordship is putting...
No, I follow that.
That leaves the
follow
middle,
that's Mr. Malinich's position. Supposing that there is bad faith, and it isn't appropriate simply to blue pencil, is the judge's answer challenged?
I'm going to put it this way, and I don't want to sound surly or grudging about it. It is what it is, and I can't seriously, nor can my opponent seriously invite your lordships to redo the kind of exercise that the judge did in doing that. He was wrong to do it. You know my case. My opponent says he should have gone the whole hog and just struck them all out. I say that's absolutely not the case. That leaves the middle ground. We're there now. And as I pointed out, the increment is pretty small between the right-hand column and the left-hand column. And if we're counting words as it happens, specifications are now longer. They've got more words in them than they had before the judge started.
I think Mr. Malinich wanted to come back once more.
No.
Yeah.
Is there more?
No, I'm sorry. That covers everything. I'm very grateful, my lord.
Sorry.
So, Mr. Roberts.
Thank you.
Thank you very much.
My Lords, I propose to reply on two topics. First of all, infringement, and there are two gauntlets which were thrown down yesterday by my learned friend, Mr. Malinich, which I shall scurry after and pick up. And the second topic is scope of validity, and this is...
Sorry, what's it? The first topic is infringement.
First topic has two subparts.
Yeah.
One infinitesimally small, arising out of my Lord Sir Christopher Floyd's question yesterday on the transcript, and one substantial part, essentially going through the table that was handed up by my learned friend yesterday with his case on infringement. And my second topic is scope of validity part 2. This is ground 6 of Skykick's appeal, grounds of appeal. And it's the point that was just being exchanged upon between bar and bench, namely, if the judge's approach was correct and if there is bad faith, should the judge have trimmed further? Ground 6 of my learned friend Mr. Malinich's appeal is the judge should have gone further and trimmed even more. And that's the point I've been left with. So first of all, the very small point on infringement. My Lords may recall that yesterday, for your Lordship's notice, transcript pages 176 to 179 from yesterday, my learned friend Mr. Malinich said that Sky did not allege broader infringement in our skeleton for the 4th hearing. We only asked on our feet at the hearing. At transcript page 77, line 19, my Lord Sir Christopher Floyd asked, well, where is Sky's skeleton for the 4th hearing? Brackets, pause, close brackets on the transcript. I don't believe my learned friend answered that question. I'm happy to answer my Lord Sir Christopher's question. Sky's skeleton for the 4th hearing, although technically it was the 3rd hearing because the 3rd judgment was delivered on the papers, is at Sky Confidential tab 1. In fact, it's the only document in that bundle. I'm not sure we even need to go to it, but it's paragraphs 24 to 27 of that skeleton that deals with the broader infringement point, and in particular paragraph 25 and 26A. As has been adverted to already this morning, the debate at that stage was what to do about the judge's finding in the third judgment that Skykick had infringed at least in relation to electronic mail services. And we said that the construction that was being placed on that finding by Skykick, essentially that it meant at most instead of at least, was unsustainable, and we said that there was support for broader infringement, and that's paragraph 25 and 26A. But ultimately, I think Mr. Malnich said he wasn't taking a procedural point, so that may go absolutely nowhere. But that's my first small point on infringement. The more substantial point is, as I said, the document that was handed up yesterday. I don't think it found a place in the bundles, but I'm looking at a landscape table on a single sheet of A4 entitled Skykick's Position on Infringement of the Selected Goods and Services. I hope your lordship still have that. I don't have any spare copies if you don't. I'm going to respectfully suggest to your lordships that it might be helpful to have at the same time open our single page landscape document, which is page 49 of the core bundle. It's the last page of tab 4 of that bundle, because the two tables roughly follow the same column and row configuration. And by looking between the two, your lordships can follow the allegations that are being made. So we're now located within ground 2 of Sky's respondent's notice. To anticipate the question I was asked on day 1 quite a lot, why does this matter? Well, in my submission, the electronic mail and computer services findings matter because, of course, those were the findings of the judge, which we say he was entitled to reach. If those findings are upheld, it may not matter so much in relation to the other cells of this table, but obviously if the electronic mail and or the computer services findings are overturned by your lordships, then these are my fallbacks. This is my safety net. So I propose to go reasonably quickly through the through the fallback points, and then perhaps in a little bit more detail in relation to electronic mail, which was my Lord Sir Christopher Floyd's question a short moment ago. So if I can invite my Lords to look down the first column of the Skykick table that was handed up yesterday. The first thing to note is in relation to goods and services number 1 and 2, we now have in unamended form infringement admitted. In relation to computer software and computer software supplied from the internet. I'm pleased to say that represents some significant progress that wasn't accepted before. The reference is para 126A of Sky's opening trial skeleton.
Then you have a finding to that effect anyway.
In relation to
computer software.
Well, we had the finding of identity, but in the main judgment, yeah. But it didn't find a landing point, I think, formally in a finding of infringement.
Well, I mean, this is admitted on the same basis that the judgment, but no wider basis.
There we go. Okay. Well, whether or not we made progress, I'm still happy with it.
Okay.
Then, item 3 is computer software. Your lordships can see both the amended and the unamended from our table, and then look across to what's said in Melodic Friends table. Item 3 is computer software and telecoms apparatus to enable connection to databases and the internet. That's the unamended form. Now, as I read Melodic Friends table here, these points of construction seem to turn entirely on making the word and conjunctive and impose cumulative requirements. So it has to be, as I read it, computer software and telecoms apparatus to enable connection to databases and the internet. If it's just computer software to enable connection to databases, then my learned friend says that is not identical, perhaps not even similar. Well, we say that is nonsensical. We say that does not accord, certainly with the judge's construction. The judge's construction of this exact phrase is at para 297 of the main judgment. And the learned judge simply used ellipses. He said he considered this service as computer software, ... to enable connection to databases, ... And I personally don't recall Skykick ever having argued this and point before now, but we're not taking procedural points like that. So we just say that is wrong. It means computer software and or telecoms apparatus to enable connection to databases and or the internet. And I would remind your lordship of Mr. Schwartz's very straightforward answer in cross-examination. Mr. Schwartz, the CEO of Skykick, was considerably more straightforward and forthcoming. He said, when I asked him whether Skykick provides software to enable connections to databases, he said yes. That's reproduced in our skeleton at page 145 of the bundle. So we say that there is very plainly use there, and of course the judge also found that there had been identical use in relation to that. So we say this.
You don't assert that Skykick supply computer software to enable connection to the internet, or do you?
I could, but I don't think I need to.
Right.
I mean, I'm
I'll
already
take that
on
as
a.
you don't.
I'm already on a fallback to a secondary case.
Yeah.
I'm anxious not to
So
introduce
you
further.
say you get home on databases, and unless it's conjunctive, then that's identical.
Yes, I'm not sure I concede if it's conjunctive, then we're out of court. But I do say it's disjunctive, and we've got a straightforward admission from Mr. Schwartz, a straightforward finding from the judge, and we say that is plainly the case. The whole function of the computer software supplied by the other side is to enable connection to databases. It's to databases of emails, email boxes, attachments, and so on and so forth. So we say that this construction point, I should say it arises several times on this table. I'll call it the and point. We say it's simply not the correct way to read trademark specifications in any event. I mean,
And that's migration and backup, is it?
yes, my lord.
Yeah.
My lord, for example, toys and playthings. Is it to be said that because something is not both a toy and a plaything, or that you get into all sorts of funny construction, even on the class headings of the NEET specification, if you make and impose cumulative requirements. We say that's not the correct way to read trademark specifications generally, and particularly these trademark specifications, and it's not the way the judge read them. And he was right to read that disjunctively. Then point 4, or selected goods and services number 4, which is data storage. Your lordships will see that the bullet point in Skykick's table gets a bit formulaic from here on in. In each case, they say on proper construction or on proper commercial construction, Skykick does not supply X. Nobody wanting X would come to Skykick. We say that's a pretty inauspicious basis for overturning the judge's findings in relation to paragraph 297 of the judgment, where he worked through and identified identity and similarity in the ways I outlined in opening. It's not really identifying an error of principle, it's just Skykick saying, well, it isn't, we don't. No one would think we do. So we say that really isn't a sufficient basis for seeking to overturn the judge's findings in the main judgment of paragraph 297.
Do you quarrel with Mr. Malinich's characterisation of the cloud backup as a backup service? And if so, would the average consumer have a backup service as falling within the description of
data storage.
Of data storage.
We don't deny that cloud backup is a backup service. I mean, it is a backup service,
Right.
but how does it operate? It takes the Office 365 documents and email and stores them on the cloud.
I think the point that's made is that you're delving into the technical substrata and not looking at it as a skilled person. Average consumer would look at it.
Well, we say that is the core of data storage. I mean, a backup is not so far removed as in the AVNet sense. We're not. We say not taking a technical point. We're not accusing them of having a website or something like that. We say that data storage, the core of data storage is the storage of data, and that's what a backup is. It's to have a separate store of these, a backup store. I can take your lordship to the way that it's described in the evidence. Mr. Schwartz, the figures in Mr. Schwartz's evidence refer to cloud backup storage. I don't think there can be any debate about the fact that there is backup storage of documents and emails. If there is denial, it's figures 18 and 20 of Mr. Schwartz's third statement.
Was there anything in the way they marketed it, for example, that suggested that they regarded it as both storage and backup?
Well, I don't, in my submission, that's a distinction without a difference, that storage, a backup is a version of storage. It's a type of storage. You know?
Okay.
The way that Mr. Schwartz adopts it in his witness statement, your lordship may remember there's a sort of a tricolor pyramid that in one of his figures, where he talks about different types of storage, and you can have disaster retrieval, and you can have backup, and you can have, I can't remember what the third one is now, but you can have different types of storage, and we say that cloud backup is clearly data storage. So we don't see any distinction between the two.
Thank you.
Oh. Okay. Mr. Hobbs would like me to refer your lordship to what's said in Mr. Schwartz's evidence. Can I invite your lordship to take up Mr. Schwartz's third statements in Sky File 1, Tab 8, page 93. This is midway through the
cloud backup storage. I can see that in
yes.
the.
Yes, and Skykick Azure storage. Now, Azure is the brand, the Microsoft brand. It's a flavour of data storage, and
beneath it, you can have an Azure storage account. Apparently.
Yes, and it's also so that's figure 18. Figure 20 is 2 pages on. You see there's some bar graphs of the storage that's used. I mean, it's all about having a separate, in case documents are accidentally deleted, and that's very much the thrust of the Skykick marketing in relation to cloud backup.
Yeah.
We've got that, for example, behind tab 10 of the same bundle, my lord. You see here, this is the promotional blurb for cloud backup.
All right.
And it stresses it's about restoring lost data lightning fast, etc., etc. So, my lord, we say that we're not straining the language of data storage to describe cloud backup as data storage. Does that answer your?
Thank you very much. Yes. What about telecommunications?
I should also say, finally, for what it's worth, I did ask Mr. Schwartz, you provide access to data storage, and he said that is fair. So, in my submission, it's fair.
You've got enough now.
Also, one last tail piece. I showed your lordships the USPTO trademark spec for what it was worth, and your lordships may remember the language used when they were describing their own use in that solemn declaration of use that was submitted to the USPTO, and in there there's reference to computer software for ... storage of email and documents. So we say that that is just a when they weren't in the witness box trying to avoid a finding of infringement, that was just how they described their software, storage of email and documents. Then can I skip over to the telecommunications services for a moment and focus on electronic mail services, because that's really the meat of it. That was what the judge said was identical in his main judgment at 297, and then held infringed in relation to cloud migration in the third judgment. We say that that is a finding which, in relation to which no error of principle has been identified by Skykick. There are a series of sort of arid technical points about niche classifications that are put forward by my learned friend, but in my submission, looking to the core, looking to the substance of what email services are, what electronic mail is, email is the whole raison d'etre of cloud migration. It's not migration of documents per se, it's migration of email. It's all about email migration. Again, the way it's promoted, to revert back to my Lord Sir Christopher Floyd's question in relation to backup, cloud migration is promoted as get ready for better email. That's, you see that from the document behind tab 2 in Sky 1. It's all about this is how you can get better email by moving to cloud-based email from your clunky, disaster-prone, localized email. And we say that it is properly and correctly characterized by the learned judge as an email service.
So, was part of the migration, could that involve keeping the same email service provider and transferring to the cloud? Or is it inevitable that when you transfer to the cloud, you're going to change email service provider?
Your Lordship may be thinking in a more sort of personal domestic context. The Skykick customers are typically more, or Skykick end users and customers are typically more SME type businesses, and there they will generally have their own hosted email already rather than using an ISP. And the transfer is to Office 365, so you're buying into Microsoft at that point.
So you are changing provider, even if I've put it in correctly, so that it's not a cloud migration isn't an integral part of a new electronic mail service. It's a vehicle for moving you from one service to another.
It's a vehicle for wholesale transmission of email, mailboxes, messages, documents, etc., from your pre-existing, as I call it, sort of legacy system. So back at Chambers, we have a couple of exchange servers down sweating away in the basement, running the email for the whole of Chambers. And if we were to be attracted by Skykick's promotional messaging on email migration, we would be able to do away with those, because all of the email boxes would go up onto the cloud. They would go off to Office 365, and thereafter all of our emails, as terrifying as it is about sensitive commercial barristers' emails sitting in some remote data center we know not where, that will take place thereafter in the cloud with no need for our local infrastructure. And we may have had Microsoft before. We certainly be running Microsoft Exchange on the local servers before, but it's just moving from from a sort of localized hardware basis to the cloud. So I think that's a long way of answering yes to your lordship's question.
So if email, electronic mail services is widely construed, obviously you say this is a service relating to email. If it's narrowly construed, as Mr. Malinich contends it should be, is it legitimate for us to say that this migration service is sufficiently similar to make no difference?
We say yes, but can I move more slowly through those steps? As I understand Malone and Friends' argument, quite a large part of it is based on the fact that email is proper to class 38. I don't think there's any debate about that. We would say this is what Malone and Friend, Mr. Hobbs was saying about cows and sheep, as I understand it. Email services are proper to class 38, and that's your lordships can see that from Authorities Bundle 3 in the 8th, 9th, and 10th editions of NICE. Email services are in class 38. Now, as I understand Malone and Friends, Mr. Malinich's proposition, he says that you have to cut down and truncate your conception of email services to fit it within the four walls of the class. For the reasons Malone and Friend, Mr. Hobbs has explained, we say that's not correct. You run into all sorts of problems if you say, you end up having to say that a conductor's baton has to be construed as a musical instrument. I think I spotted something in the NICE classification earlier when Malone and Friend was on his feet that. Your lordships needn't look it up, but it's page 706 of Authorities 3. Socks are proper to class 25, but electrically heated socks are proper to class 9. And therefore, my learned friend would presumably be saying, if he sold electrically heated socks, that they weren't socks, because electrically heated socks are proper to class 9. So that's a good reason why the class headings don't come down as guillotines to confine the natural wording. We say that electronic mail services means what electronic mail services means. It's not construed by the class. So that, as I understand it, is the first way that it's put. I think he says in any event, electronic mail is all just about sending and receiving messages. It is no more than sending and receiving messages. I think the way that my Lord Sir Christopher Floyd put it was it's Gmail, give or take. My Lord, with respect, what Mr. Malinich is describing there is instant messaging. It's ephemeral pinging backwards and forwards of messages, as like Malone and Friend and I passing post-it notes to each other. It doesn't have the email services in my submission are much more than that. Even Gmail, when I log on to Gmail, I log on to my inbox. If I'm organized, I have subfolders of my inbox where I categorize and store important emails. I can attach files to them. I can do all sorts of things beyond merely pinging emails, pinging messages backwards and forwards. So we say that's a very impoverished construction of email services. That would have been the case in 2003, 2003 doesn't matter because email services only appeared in the 2006 and 2008 registrations. But we say that is as a matter of natural language, it's a wrong constriction and construction of email services. And my Lord, I'll even meet Mr. Malinich on his own territory. Okay, so let's say that email services are just the ephemeral pinging backwards and forwards of messages, either as a matter of natural construction or as a matter of confinement within class 38. We say even then, migration is transferring email from the hard servers to the cloud. It's moving the data. And those aren't my words, my lord. Those are Mr. Schwartz's words in his witness statement. It's paragraph 9 talks about the transfer of email. Paragraph 12, moving the data. This is about sending electronic documents from A to B. It's telecommunications, my lord. It's moving the... Your lordships will have seen some of the other goods and services that we've highlighted in the NEE specification. For example, I'm in the 8th edition of the NEES classification, page 709 of Authorities 3. Transmission of messages and images, brackets, computer aided. That is proper to class 38. We say that this is all within the scope of sending messages, sending mailbox, sending electronic documents, and that is the essence of what cloud migration is. That's what I was proposing to say on cloud migration, unless I can assist your lordship further in relation to email services.
Can I just come at it from the other end for one moment? Mr. Melanich says, well, relating to is just much too broad. And he's not merely relying on class headings or the like, he's relying on the other materials that he's put before us. Is he right about relating to being much too broad?
Well, my lord, first of all, as I'm sure your lordship is aware, relating to doesn't appear in the specification of the trademark, it's electronic mail services. This is whether the judge, by saying migration services relate to electronic mail services, was going too far. Well, I'm sure that I could come up with some things, and I dare say Malone and Frank could come up with some things which relate to electronic mail, which are not identical to and not similar to. We say email migration services are something that relate to email services. In fact, they are email services. They are embraced within that term. So whether or not there are some constructions of related to that might take you outside of identity, even outside of similarity, doesn't matter, because the judge's actual finding is unassailable, we say.
Yeah.
I think somewhere, probably in the discussion argument, there was an analogy with postal services. If you had a heading of postal services, it covers people who carry letters from A to B. He said it wouldn't apply to somebody who took a whole lot of letters and stored them somewhere differently.
Well, that's not, with respect, the best example. I didn't think my learned friend's example about visiting Europe and visiting France was particularly good either. But this one, postal services involve all sorts of things in terms of, as a meaning of natural language, not just confining them within a particular class or something. I mean, one only needs to visit Mount Pleasant to realise there's an awful lot that goes in terms of storing, sorting, delivering, insuring, getting proof of receipt, all sorts of things involved in postal services. But again, I mean, that's just a different term. I'm not sure how useful the analogy is, but in the same way as we would say postal service is more than just one person picking up a letter from A and delivering it to B, so electronic mail services is much more.
So insurance can be a postal service.
Postal insurance services could be a postal service, yes. Even though insurance would be proper to class 35, class 36. This whole idea that you've got to fit something into one class or another really breaks down. I mean, if you can look at the explanatory notes to the NEES classes and you see what does and doesn't fall within certain classes. I think legal research services fall within one class, but legal services fall within another. It's impossible in certain cases where in the real world to simply, force a square peg into a round hole or a round peg into a square.
Why are the classes there at all? What function do they
Well,
fulfil?
that
in real
sounds
world?
that sounds like a Mr. Hobbs question, but that's more.
I'll treat that as a compliment.
That's more. Yeah, you were there, weren't you? I don't know. The NIS classification is very venerable. It seems to be a bunch of sort of Edwardians sat around a table in a smoking room one day and said, I say, what sorts of things are there in the world? Well, there's musical instruments. Okay, let's give them their own class. It's quite arbitrary if you look through the goods and services. And it's just designed, as it says in the foreword to the NIS classifications, which your Lordship may have seen. It's just a sort of a way of administering trademarks. It's not the sort of thing I think we would necessarily design in the same way if we were doing it now.
It does assist searching for prior mark.
It does in most cases, but because there's so much
Not
overlap now.
foolproof for that purpose.
Yeah, and I say Class 9 is a good example because I'm really not sure that we would necessarily class software as in Class 9 goods nowadays, but that's the way it was done because originally software was something you carried around on a floppy or a hard drive or a piece of punch tape. And if you want a more learned answer, I'm sure Mr. Hobbs is available. We therefore say that even on the narrowest of constructions, where it's just moving messages from A to B, that's what migration does. In relation to cloud backup, well, backup of email is one of the primary functions of cloud backup. I mentioned to your Lordship, I don't know whether I took you to your Lordship a moment ago, to tab 10 in Sky's bundle. That's the promotional blurb for cloud backup. And it's all about restoring lost data, and it's cloud backup for Exchange Online. And your Lordships may be aware Exchange is the Microsoft email product. Therefore, it's all about what happens if you delete or lose that key email, that job offer, or the Chancellor chasing you for a late judgment, or whatever that key email might be. We therefore say that even in relation to cloud backup, that is properly to be regarded as an email service. It is an email backup service. So we say that the judge could have gone on to say that whether it's identical or whether it's similar, we say it's within the purview of electronic mail in either case. Then I skipped over telecoms. And the reason I did that is because the judge takes the view in the third judgment, paragraphs 30 and 58, that email is subsumed within telecommunications. I think not just in a pre-IP translator way, that the class heading covers everything. TV broadcasting, telephony, broadband, etc., etc. But on the basis as a matter of core and natural construction, it includes email. We respectfully agree. We don't see anything that is said by the Skykick on the point as being as identifying an error of principle in what took place, and we therefore say that the greater includes the lesser. And indeed, Skykick have appealed against the finding of identity in relation to telecoms. I was a bit ambivalent as to whether the judge had held infringement of telecom services, but certainly, maybe out of an abundance of caution, Skykick's grounds of appeal appear to envisage that he has found that, and we say no basis for disturbing that, both in relation to cloud backup and in relation to cloud migration. Internet portal services, I can deal with a little bit more briefly.
Can I just come back to my question? I suppose, supposing that the narrow construction of electronic mail services is correct, and it's related. It is related to email services, but isn't actually an email service.
Well, yes.
Mr. Malinet says, well, we can't start now looking at whether it's sufficiently similar.
We respectfully disagree for the reasons that my learned friend Mr. Hobbs addressed you on in relation to the INEOS case. There is no, it's a matter for the court, it's a matter for assessment.
Wouldn't one expect some evidence of who one would expect to go to for a cloud migration service, as opposed to an email service strictly so-called?
Well, my lord, one only needs an email migration service if one is using email. The get ready for better email messaging, cloud backup for Exchange Online, are all addressed to someone who is consumers of email services. We therefore say that
do I ask my existing provider of email services for help with migration?
if they're a partner, then yes. Then the evidence was there were tens of thousands of I'm talking partners with a capital P. Your Lordship understands that from the nomenclature of the judgment. So yes, we say that I don't need to invite your Lordships to go to get your Lordship's hands dirty with the evidence. We say that that is something which is plainly open to your Lordships. And even if your Lordships are concerned that the learned judge construed email services too broadly, we say it is plain that they are sufficiently similar, bearing in mind all of the other aspects of the global appreciation test which aren't even under appeal. So distinctive character of Sky, household name, the nature of the average consumer, none of those things have been appealed. The only variable in the sensitivity analysis that my learned friend is tweaking is identity versus similarity. We say that the infringement analysis is not poised on a knife edge, it's not a hair trigger. We say that there's plenty of room there for similarity to still be infringing. Does that answer your Lordship?
Yes.
Yes, I will. I'll perhaps show your Lordships in a moment what Mr. Schwartz said in cross-examination, but I don't need to. In relation to email services, in my recollection, I put it to him. I'm not going to do it in my recollection. I'll do it on the basis of what was actually said. The cross-examination transcript is in our reply skeleton, which is behind tab 10 of core 1. And I think this is where the related to issue arose. It's page 145 for the bundles. In relation to item 6, I put the question to the witness: you provide services in relation to electronic mail, we migrate email. That's a service in relation to electronic mail, is it not? Migration services, yes. So my learned friend would say that's why we are talking about in relation to. I can't rely on that as an admission that they provide email services, but we say that the tenor of the promotional literature is such that these are the same end users and customers self-evidently, because they're people who have email that needs to be migrated.
You didn't ask him whether he provided an email service.
I didn't, which is a pity, because I was getting so much low-hanging fruit in that passage of cross-examination. Maybe I should have chanced my arm. Internet portal services, I don't propose to repeat what I said in opening in any great detail. To my mind, this all comes down to the question of provision of portal services to third parties, which was the reason the judge didn't think or was sceptical about whether we provided internet portal services. I have given your Lordships the reference to Schwartz, para 41, where portal services are provided to partners for onward use by customers. which I say is a provision of portal services to third parties if that's required. So we say, and the evidence shows that in order to access either of the products, either migration or backup, customers go through and partners go through the for that purpose by Skykick. The final one is computer services, etc. So computer services for accessing and retrieving information / data via a computer or computer network. Again, this was the subject of a fairly straightforward answer in cross-examination. I said, and those computer services retrieve information and data from a computer network? Yes. So I'm not quite sure the basis for the statement in this table that was handed up by Skykick yesterday. Nobody would come to Skykick to help access or retrieve their information / data. Well, that's not what the CEO of Skykick said under oath. So we say that the judge was well placed to assess that and was correct to find that cloud backup constituted. To be fair, the learned judge found that there was infringement in relation to the amended term. I'm talking now about the unamended term. But we would say the greater includes the lesser, because the change really is in relation to content / documents as opposed to information / data, which might be said to be a slight narrowing. But we say that in relation to the unamended term, there is plainly identity, plainly infringement. The USPTO specification to computer software for the retrieval of email and documents. So my learned friend, I think, says that backup is not access and retrieval. Well, they thought so when they were doing their USPTO spec, when they were describing the use that was being made at that stage, computer software for retrieval of email and documents. And we say that that is plainly the case. That's the function of it is a live backup service. It's not a sort of daily archive or a daily log of documents. It is a sort of live, contemporaneous, constant backing up to remote storage of Office 365 electronic documents and email. And therefore there is, in a sense, constant access and retrieval backwards and forwards. And the evidence of Mr. Schwartz shows that one can... Sorry, I'm distracted by the...
I'm sorry, well, it's quite fun.
We say that in relation to the unamended term, there was plainly identity, and saying that no one come to Skykick to help access or retrieve their information data. Well, the promotional literature, restore lost data lightning fast, data loss happens even in the cloud, the cost of getting back on track. It's all about retrieving lost data. Then I can take the second column, the as amended by the judge, quite quickly, because it seems to be really just the same point all the way down. And it's another and construction point as I see it for the most part. So in relation to item 3, in relation to item 4, and in relation to item 8, the point that's put here is Skykick doesn't supply any goods or services in relation to content or documents that are audio-visual and or audio-visual. Now, on the transcript yesterday, I believe it was my Lord Justice Newey put to my learned friend, you don't mean that the documents have to be audio-visual and or audio-visual. And I recall that my learned friend said, no, we don't say that. So as far as I can see, this point falls away from the table. But what I understood my learned friend to be saying in its place is that there's something important about content and documents. That there's got to be audio-visual, visual, audio-visual content and documents. There can't just be documents. We say that that's another with respect, unconvincing point of "and" construction.
I don't myself get that out of this table.
No, my lord, that's my recollection of Mr. Malinch's fallback position in on his feet yesterday. If I've got that wrong, I'm sure he'll correct me. But I think the point that is set out here died a death fairly fast at in response to questions from the bench. And as I understood it, the fallback was they have to be documents. I haven't actually got my table in front. Here it is. Yes. Is that it has to be audio-visual and/or audio-visual content and documents, and also that it has to be computer software and telecoms apparatus, which was the point made in the left-hand column as well. So, if I'm wrong, that would be I'll be pleased. But that was how I understood the Learned Friend submissions, and we say it's wrong. So. With that out of the way, we say that all of these references to documents, which is the main part of the qualification and the amendment that the learned judge made to in particular the downstream services, goods and services, is a distinction without difference for the purpose of infringement, because both of these software products, cloud migration and cloud backup, operate in relation to electronic documents. In cloud backup, quintessentially, because it is actual, what I would call a Word document, a .doc file. In relation to cloud migration, it is primarily email. I mean, there may be some documents attached to emails, but we say that email messages are electronic documents, and therefore, in relation to each of those references to documents, we say it is amply satisfied by the cloud migration product as well. I don't need to go so far as to say that any of the software is supplied in connection with TV or video recording. That isn't really where the centre of gravity of our case is. That's the first term before the semicolon in the first amended term. What we place reliance on is computer software supplied as part of or in connection with a telecommunications service. And in relation to that, we rely on the judge's extended definition of telecommunications. And we say that's plainly the case in relation to the two products in issue. So, my lord, those are our submissions in response to the table that's been put forward by Skykick on infringement. If your lordship have any more questions in relation to our response on infringement, I'm happy to take those now. Otherwise, I propose to move on to...
Can I just ask you, just so I've understood this, the judge makes a finding of infringement, and that's what finds its way into the order. If we uphold that finding in relation to any one of these, whether the amended or unamended form, depending where we end up on that point, we don't need to consider all the others. It doesn't make any difference to you whether you have infringement of 8 classes or infringement of 1, does it?
Well, my lord, we're back to the answer that my learned friend Mr. Hobbs and I gave you yesterday. Your lordship will have seen the rearguard action, I hope that's not too pejorative way of putting it, that took place between the third and the fourth judgments. We got a finding in relation to at least email services. The judge thought that was sufficient. That was determinative, in his words, of the case. You know, the killing blow had been delivered, but like the Black Knight in Monty Python and the Holy Grail, my learned friend sprung up and said, email services was but a scratch. We don't infringe in relation to anything else. There shouldn't be an injunction, or if there is one, it should be a very narrow injunction. So we said, okay, we say you infringe in relation to anything else. And the judge said, well, it's sufficient to look at the high water mark in relation to cloud backup, and he identified the computer services, the 8th one. Our concern is that is the sort of approach we've got from the defendants. We say, as we said actually to the judge at the fourth hearing, we would be happy with at least email services, we would be happy with at least computer services, but we just want there to be clarity and no wriggle room for the defendants when it comes to downstream relief. And I think the way that my learned friend Mr. Hobbs put it very invitingly, if I may respectfully say so, is that provided we've got the clear findings of some infringement, we would be content, and I think Mr. Malnich said he might be content for it to go to the next phase, namely quantum, on the basis of the extent of infringement being left over and not necessary for this court to, as I think as my learned friend Mr. Hobbs put it, bend over the papers and identify 16 different types of infringement.
You must be content, mustn't you, if there is a finding which catches both products. I can't really see the value of findings which catch those two products in different ways.
My lord is with respect preaching to the choir on this. This was the very tenor of that of our skeleton in the confidential bundle I took your lordship to. We said yes, the product infringes and that's sufficient, but we have defendants who won't lie down. That's why we press this point. Also, I mean, obviously it is run as a fallback if your lordships aren't satisfied in relation to electronic mail.
Well, I understand that entirely. You're facing an argument that you don't infringe any of them, so you have to say why you infringe each of them.
And that's within our respondent's notice, and we say that's those points carry the day. But yes, the other points can, if your lordships are satisfied in relation to the infringements found by the learned judge, the rest is icing on the cake. But we just would.
Well, you say you'd like the icing, but in terms of the formal order, all you have got, and my understanding is this is standard practice, is you don't actually have any declarations at all. You just get an injunction against infringing and damages or an account of profits from the infringements, but nothing specified in the order saying which bits have been infringed. And that is, I think, standard, is it not?
My lord, yes. But the whole of that fourth hearing was the defendant saying there should be declarations of non-infringement, there should be cutting down of the injunction. But you're, with respect, your lordship is absolutely right. The injunction we ended up with is thou shalt not infringe.
And your respondent's notice doesn't say we want declarations that you infringe 1, 2, 3, 4, 5, 6, 7, and 8.
No, our respondent's notice says, well,
it says we want it upheld for these reasons.
Yes, following further or better reasons.
Thank you.
My lords, I shall certainly be finished in good time. My second and smaller point is scope of validity part 2. So this is Skykick ground of appeal number 6, not number 5. Number 5 of their grounds of appeal is these computer services, for example, should be expunged entirely. I think my Lord Justice Newey put it blue pencil, should be blue penciled. But ground 6 is if the judge was correct, then he should have gone further and trimmed down even more. And it's ground 1, little Roman 2 of our respondent's notice. Why does this matter? Well, it's a safety net underneath a secondary case. Skykick's primary case, obviously, is that they should be deleted altogether. But we say that if the trimming approach was correct, and I believe this is the answer my learned friend Mr. Hobbs gave your lordships just a moment ago, is that we are not saying the judge should have trimmed less, we're saying he shouldn't have trimmed at all. Whereas my learned friend does say he should have trimmed more. That's their ground 6, and that's what I address now. This, I'm afraid, is another comparison of 2 tables. These submissions could have been a Scott schedule. Could I ask your lordships to look at, it's 2 pages in the same volume, I'm afraid. It's core 1, tab 9, page 127, and tab 10, pages 139 to 142. So that's core 1, tab 9, page 127, and tab 10, 139 to 142. The table your lordships see behind tab 10 is a response to the first document. Now, my learned friend, I don't think, took your lordships to this and didn't really spend any time on his secondary case, but I didn't understand him to be withdrawing the ground of appeal. What is said is that if the judge's trimming exercise was correct in principle, this is the residue that should be trimmed down to. Now, this is in fact just the same document that they sent to the learned judge below before the third hearing. So, for example, you see entries in relation to telecoms, electronic mail services and internet portal services, which we don't understand to be an issue on the appeal, but that hasn't been tailored for the purpose of this appeal. We have the reheated leftovers of the argument below instead. I think I should take this very quickly because it wasn't really majored on by my learned friend. We say that sending and receiving email, which your lordships see as about the 5th term underneath Roman 1 computer software, software for the purposes of sending and receiving emails, does not begin to do justice to the email services which Sky was actually providing at the date of filing the trademarks. That is, we say, for the bottom of page 141 of the bundle, the last bullet point there, the evidence demonstrated that Sky's electronic mail service included not just rudimentary sending and receiving of email messages, but extended to, for example, email uploading of content, secure storage within folders and mailboxes, importation of contacts, remote access, email, and so on and so forth. And the references are there given. So we say that it's quite wrong. I mean, for obvious forensic reasons, they say that that's what what it should be cut down to. But we say that is quite wrong. The Sky email and the Sky store and share products, as at the time the marks were applied for, were very substantial and had a whole host of rich features way beyond simply sending and receiving emails. I'm not going to go through every. I would commend, with respect to your lordships, the detail of this table. I don't think it would be profitable for me to grind through it. I will, however, take one last point, which we say in relation to data storage. Data storage in Class 9. Skykick says that that should be written down to software for uploading and securely storing, organising, printing, viewing and sharing photographs, music, video and document files. Well, my lords, we say that even if we're wrong on every other point and Skykick is correct that that is what we should be entitled to in lieu of data storage, that sounds like a pretty good description of cloud backup to me. Uploading and securely storing document files, unless we're going to be taking points about conjunctive ands, which I say we shouldn't be concerned with. And the evidence, or part of the evidence, of Sky's use in relation to storage of documents, and in particular, can actually just be found at paragraph 46 of the main judgment. The judge refers to Sky's activities in allowing for document file storage. So we say that even if everything else goes against us, nonetheless, on their own rewording of data storage, there would still be infringement. My Lords, unless I can assist your Lordships further, that was all I was proposing to say in relation to scope of validity part 2 and indeed anything.
I don't detect any more questions being asked, so thank you very much, Mr. Roberts. Mr. Mount.
My Lords, unfortunately the issues have become more, not less, complex in terms of their interrelationship as this hearing has progressed. And that is wholly due to the propensity of my learned friends to change the infringement case at every stage, change the bad faith case at every stage, and level new allegations based on new points that have never been considered by the lower court or advanced by my learned friends. Now, why do I say that? Consider this. There has never been a finding by the judge on the amended specification, save insofar as the email services and very belatedly the computer services. What's it? Never been. But my learned friend, here before you, as if he's doing a closing speech to the judge at trial, contends for similarity. And there's a temptation there. You might be tempted to even say, well, seems fairly common sense. He's not permitted to do that on appeal. First point is I've been deprived of a tier of fact-finding. He can't come to this court for the first time and ask you to make judgments on findings of fact that were not made below. But it's worse than that. There's every sense in which these were saved up for the appeal. Why do I say that? Because when you look at how the fourth judgment was given, my learned friend took you to the confidential bundle which contained his skeleton, as if to wave an arm and suggest that it was all an issue. It was not an issue. There was no issue other than email services coming into this hearing. There had never been a finding in his favour on any term, in terms of construction, in terms of identity or similarity at this point. And this was the last hearing. A spat develops over what the declaration should be, what costs should go, and so on. And he's right. We thought, well, the only finding you have so far is email services against one part of our business. And perhaps we shouldn't have got started on that. But the judge used the words "at least." It doesn't really matter whether that was judicially correct or not. The fact is, he has never ruled on these points that are being put to you. So, given that my learned friend seems to be saying that if there is a finding of bad faith, he's stuck with the judge's amended specification, he won't be saying to you, if there's a finding of bad faith, I don't want anything, my terms all get unscathed. That would be deeply unattractive. That's why I interrupted him to get that confirmation. If that is right, then what on earth are we doing considering the terms in the first column, the terms in the second column, and so on? If we keep it simple, my lords, I would urge my lords to approach things on this basis. First of all, was there bad faith? Simple question, yes or no. You might be with my learned friend. There's no bad faith, in which case he gets me on all of those first column. And that's fine, more or less. Not all of them, but some of them. But there was.
Does it matter to you how many?
No, it doesn't. Well, as long as it gets both part of the business.
Exactly.
My lord, that's another problem. It's never been clear which part of the business is said to be. That's part of the problem why you cannot decide this. Because we only had email services against migration. The judge flipped at the final hearing, at a form of order hearing, and said, oh, well, I didn't really think about the backup side of the business, and so I'm going to find a new part, a new term, is infringed by that part of the business on a different legal provision. Not very convenient for my client facing an injunction at that form of order hearing. But let me put it this way. My learned friends have sold the pass on those other terms. They can't. There's another reason. Because the fact that they came into court at the fourth, at the final judgment, before the fourth judgment, and said on their feet, Mr. Roberts on his feet, in that skeleton, not having even asked in this skeleton for a finding on computer services, not having asked, because it just says, in the circumstances, I don't think he showed you paragraph 27. That was the purpose of, sorry, it's a confidential bundle, tab 1, paragraph 11. Paragraph 27, in the circumstances, there's no rational or fair basis for Skykick's proposed declaration of non-infringement. So what they were saying was, don't grant Skykick's non-infringement declaration. There was no request for a positive finding. Notwithstanding that, on his feet, my own friend Mr. Roberts said, Judge, we would like there to be an express finding, much as the same way he did to you a moment ago, my lord, with Justice Nugee. He said, we'd like there to be express findings on these things. It'd make our life easier. And the judge asked, well, which? And he said, computer services? And that was the only one that was considered at the time. And I was asked for submissions on that, on the day, for the first time, without reference to evidence, without it having been adumbrated in any way. Now, do I take a procedural point on that? No. But what I do say is that my learned friends have sold the pass on all of those terms other than email services and computer services, which begrudgingly we are prepared to engage with. Through clenched teeth, we're prepared to engage with. But we should not have to engage with that either, because the only finding that he can appeal on the facts, there's no reasoning for this, is email services. Very little reasoning, in fact, very little construction. My lords, we say the first question is bad faith. If there's bad faith, we're into the territory of what to do about these terms. Now, the deeply unattractive prospect that I thought my learned friend was saying was, I keep the terms that I sued you on in a distant field, 9 years of side-by-side use, no confusion. I keep those terms that were notionally close to you, even though I'm a bad faith actor. And these are my best terms. You can assume there's a lot more bad faith in the withdrawn terms. These are the terms that I've deployed. So my lords, that's the first question. If there is bad faith, he's now confirmed we're into either blue pencil or rewriting. Blue pencil or rewriting. And I want to come back as to the reasons why we say blue pencil is absolutely the best course. It's the safest course. It's the course that's consistent with Sky's own behaviour. They were put to proof. They were asked to come up with an amended specification following the clear bad faith after the Court of Justice, and they sat there with their arms folded. No, you do it. Or we don't care, you're wrong. How are we supposed to decide what the extent of their good faith is within these umbrella terms? That's what we said to the judge, but the judge decided to do it for them anyway. No, they didn't ask him to do it, and even though they sit here today appealing him for having done it at all. I wanted to just make some general points about how these 2 points fit together, because we say the infringement questions actually tell you a little bit about the bad faith questions. Look how much time one can spend debating the ins and outs of the word and, whether the class heading has this or that to do with it, and so on. Again, can we just keep it simple? It is simply this. What is the thing? It's a backup service. You see that? It's a backup service written in any of the specifications? No. End of story, end of analysis. These are trademarks. to be used in the course of trade. Migration. Doesn't matter whether it's Office 365 or a suite of accountancy programs. Doesn't matter. There's a migration service. That's its fundamental core. Is that what is written in any of the terms? No. Well, then that's the end of it. Leaving aside, we were over-generous, in fact, allowing Sky even to debate these points. They should not be before the court. But if they were, they're hopeless. All of them are hopeless, save for one. And I wanted to address you that right at the outset. Computer services, computer software. And I know my lords were concerned about that yesterday afternoon. Now I have to say, my lords, again, this case has been bedeviled by a constantly evolving case, which for a party in the position of Sky, with their 8,000 word trademarks that they refined to 9 words terms 3 weeks before trial, is not a particularly satisfactory way. The case is being run in the same way and along the same theme as Sky applied for its marks. That's unhappy. We say there should have been a change after the bad faith findings of the court. Now, just if I was going to say, if I could just deal with computer software first, because I know that that was a concern for my lords yesterday. And then I wanted to make some general points about how infringement and the grounds of validity intersect. And then I'll just respond to a few miscellaneous points made by my learned friends. In terms of timing, I would probably be about 45 minutes, maybe an hour maximum. I hope that's not too long. So, on computer software, my lords, and I'll tell you that very quickly before lunch. The suggestion was that there was no cross-examination on this. This term was just left alone. What sort of lawyers are we supposed to have been? We didn't have an eye on these points. It's computer software, the thing that we do, you know, the sort of most close term. We were said to have left it alone, not cross-examined, not argued, and lo and behold, it infringes. My lords, that is so far removed from the reality. The position is this. The particulars of claim, there are 5 marks. The first 2 marks contain computer software by stealth. They're a class heading. They secretly contain computer software. My learned friend was asked yesterday whether he accepted the judge's finding of effectively bad acting so far as registration filing strategy was concerned. And he said, I can't get behind the effect of 250, the judgment, and he can't. It doesn't really matter whether he says he can. But then he slipped in one little response. He said, oh, that's all in the presidential communication, 403. That's the thing he showed you from OHIM, where they said, we interpret, when you use some of these buzzwords, like the actual buzzword is data processing and computers, that encodes the words computer software. When you put those in, we're going to treat that as a term of computer software. You get computer software. The problem is, it doesn't work, because 2 of the marks were applied for before the presidential communication. 2 were. Right? And that contained the class heading. And in fact, all 5 of them contained the class heading, as well as the specifically called out term, computer software. Duplicative protection in the last 3, and pre-presidential communication advice in the first 2. And of course, 1 is a UK mark. Presidential communication doesn't make a blind bit of difference to a UK applicant. I mean, I should say I represented the UK in the IP translator case. That approach did not apply here. We had a class heading means what it says. If you apply for data processing and computers, that's what you got. You don't get software. You've got data processing and computers. That's not software. It doesn't say software. It's unclear. And the UK went to the European Court Grand Chamber and said, everybody should do it like we do it, because it's much more clear. And about 5 or 6 member states agreed. Few didn't. The ones that don't pay much attention to the trademark system allowed anything to be registered. And the EU IPO, as you heard from a learned friend, saved on translation costs, or you got more money by filling in these classes. This was no safe reliance at all in terms of a registration strategy. And Mr. Tansey, in his witness statement, and I'll ask you to note, makes it clear. At paragraph 27, there was no change before or after he arrived at Sky. So it wasn't as if they, oh, what a great idea. The presidential communication has told us it's okay, so we're going to apply for umbrella terms and then narrow. No, it was the policy of Sky to populate the register. And on this, it was suggested I didn't cross-examine. Most of the cross-examination of him was on the point about class headings and sneaking in all the terms through the class headings, which is exactly what all 5 marks had. Why would I do that unless it covered computer software? That's the thing that they said was closest, and which perhaps on an objective view is closest. Oh, that is an astonishing submission. We had Mr. Pearce, another witness. His sole function was to talk about the Sky use and the breadth of the use and the intention to use and so on. And that's exactly what I cross-examined him about. Cross-examination was about showing they're actually quite narrow, the Sky business. It's not as big as they say. You know, when you have your phone for streaming Sky Sports, it's not just a generic app. It's an app that does a thing. So that's a particular kind of software. We just say, we did cross-examine and we challenged. What happened next? And this is where it really gets interesting. This is where you see that the strategy of the way the case is argued matches the application behaviour by Sky. And it's this way. My learned friend actually makes note, he's quite open about it. People should register what they want. Big brands should have what they want. That's his submission. Look, I think perhaps at that stage I will come back and show you the letter that followed the ECJ judgment, where we told them, you've been caught in bad faith. Now, what is your amended specification? And they refused to say. Refused. We put in a skeleton argument with an amended specification of our own. We don't know what their good faith or bad faith is. We based it on the evidence. Do it, Sky. Tell us what it is. They refused. They refused on the 3rd judgment. They refused on the 4th judgment. And they refuse now. So they are not prepared to countenance any partial invalidation, and I'll show you after lunch why that is, what position that puts them in. My lords, I think I've got
this is a convenient moment, in which case, 2 o'clock.